report done. And Mr. Chapman, do you object to that competency report and the finding?
I was unable to sufficiently discuss that finding with Ms. Andrich, so I do not.
All right, Mr. Schmidt and Mr. Chapman, and if you're unable to do that, what do you want to do? Reset this?
It's not a new competency finding. She's already been found not competent. This is a review, and according to the document, it doesn't look like there was much of a change.
I'm not watching you, Ms. Andrich.
It doesn't look like the doctors are noting any changes. I think we just continue to wait until an opportunity arises for her to be returned to competence or for the 1 year to expire.
I thought that they were asking that she be brought in and regain competency at a facility. Maybe I read it wrong.
Right out of the gate, the defense attorney drops a bomb. If she were competent, the first thing she'd do is fire me. That's not exactly a confidence booster, but it also shows the tricky balance here. Competency isn't about whether someone likes their lawyer, it's about whether they can meaningfully participate in their own defense.
Andrew. Andrew, stop talking.
I only see not likely to be restored to competency.
This is an updated form. I've updated one for something I read. Oh, there was, okay. There's that order for commitment. Then she was committed?
I'm not aware of that. Is that a separate case?
I'm a bit... Oh, wait.
I just see the ma'am.
You need to stop talking or I'm going to have you out. Okay?
Here's the key legal backdrop. Once someone is found not competent, the court checks in periodically. If doctors say there's no improvement, the case basically hits a pause button. Think of it as the justice system waiting in limbo. No trial can move forward until competency is restored or the statutory clock runs out.
I just see that she lacks...
No, it was from the letter. It was from July 3rd, 2025. From Melanie Leonard, DHS Forensic Mental Health Section. And then we did receive then the competency report from Kristen Jackson.
I think they were having trouble finding her. Right.
All right, so Mr. Schmidt. I don't even know where she is. I don't know what she's doing.
Well, what it indicates is she's not doing outpatient competency restoration right now because they didn't think she was appropriate. She's on a waiting list for a mental health hospital. So,
yeah, that was my understanding. The waiting list is issue. So,
they're not requesting a warrant or her.
Sandra, I'm going to have you go outside, okay?
They're not requesting a warrant or for her to be taken into custody.
Stop talking until the judge asks you a question.
If you cannot say any word, you can stay right there, okay? But no matter what happens in here, I have to understand where we are. So do the attorneys. Mr. Chapman will talk to you after and explain everything to you, okay? All right, so it's your...
Did you catch that? Andrea blurts out, "They set me free." But this isn't freedom in the sense she thinks. Judges often have to walk a fine line, letting defendants speak versus keeping the record legally clean. Her outbursts here, they actually highlight the very competency concerns at the heart of the case.
Her understanding by review, they're not stating that they want to take her into custody right now, but that she's on a waiting list, and right now she'll just stay where she currently is.
They say they're not requesting it right now, but that it may be requested should difficulties arise with voluntary admissions. I think what they're saying is she's on the waiting list, and if she doesn't comply with going to mental health at that point, then they'd be asking for a warrant. That's my reading of the July 3rd.
All right. So right now, that's our understanding. We have no further update as to that. She's currently in a group home. I am going to tell you, Ms. Andrich, you have to comply with everything that they say, okay? They need you to do some kind of assessments or tests. You must voluntarily, you must comply, okay? What would you like to do? Should we set this for another hearing? Should we kind of let it go?
Judge, to be honest, she's already been found not competent, and we're in the competency restoration phase.
This is crucial. The judge basically warns her, follow the program or things get worse. In plain terms, if Andrea doesn't comply with treatment, a warrant could land her back in custody. This isn't just about her mental health. It's about public safety and ensuring the case doesn't stall forever.
I don't really see that there's much of a purpose for advocate counsel at this point, and I could tell you if she were restored to competency, the first thing she would do is fire me. I don't think I'm serving much of a purpose here. I would just ask to withdraw. If she's ever found competent and wants me back, I'll happily be reappointed, but I'm not doing much in this case.
All right, then I will permit your withdrawal on the record, with the understanding that if needed in the future, you'll be approached. We can go that route. Okay. All right, so that's where we are. No. Perhaps we should set just the status in this. Maybe 9 o'clock on November 4th, just to figure out where we're going, if anything's transpired, if we haven't received anything further from DHS. 9 o'clock? November 4th. All right. There we go. So, Mr. Chapman, can you come up and get her notice?
I will.
Thank you. Then we are free to leave.
And wow, the defense attorney officially bails out. But here's the nuance. It's not abandonment. Lawyers can withdraw if they genuinely can't serve their client's legal needs, especially in competency cases. The court leaves the door open to reappoint him later, like hitting pause on the attorney-client relationship.